So let me welcome the conference participants back. Let me welcome some external guests that join us for this session in particular. We look back at a day and a half of intense debates around reimagining the legal building blocks of the economy, contract, property, cooperation, and competition. And really a common thread of our discussions in the last day and a half has been how to process social change in law, how to balance between the possible and the visionary, and what role legal thought has in both triggering and sustaining new imaginaries. And for all of these questions, we could not have a better concluding keynote speaker than Professor Roberto Unger. While of course needing no introduction, let me just say that Professor Unger is the Roscoe Pound Professor of Law at Harvard Law School and one of very few current thinkers whose really globally received work unites law, social, and political theory from a critical perspective. Professor Unger's writings, from his early role in the critical legal studies movement to his latest works on the political economy of the knowledge economy, take the possibility and the need for transformation and constant re-intervention of legal institutions as a guiding theme. And in this, his work inspires and really fuels many of the individual projects that we've had in the last day and a half here in this conference. And lastly, by being both a global thought leader, but then also a political figure, Professor Unger has been invested in building not only academic, but also practical alliances, which boost, if this vaccine jargon is permitted, the project of legal imagination. Professor Unger, we're delighted to welcome you. We thank you for your time and look forward to your lecture and then the discussion afterwards. And for the session in total, we will have 90 minutes.
Thank you so much. So I take it that the general theme of our meeting is legal thought in relation to transformation and transformation of institutional structure in particular. And in that spirit, I propose to offer 5 propositions. I'm going to state them dogmatically, the better to preserve much of our time for subsequent discussion. So the first proposition is that there is a particular style of legal doctrine of the rational reconstruction of law that is now being disseminated throughout the world as the wave of the future in legal thought. And from its main bases in the legal academies of the United States and of Germany. And I want to argue that we should resist this form of rational reconstruction of law and deny its credentials to represent the future. So what is this form of law? It's the idea that law should be interpreted purposively or teleologically, but that the vocabulary in which we describe the guiding purposes should be the vocabulary of general principles of right and policies responsive to the public interest. And so it unites a finalistic purposive element with an idealizing and systematizing character. Why should we resist it? We should resist it first because it is a mystification of law. That's not what law is like. The characteristic content of law in every branch is the existence of certain dominant solutions surrounded by a periphery of deviation or contradiction, which this approach to law radically understates. Secondly, we should resist it because it is an invitation to the usurpation of power, especially of democratic power, by the legal notables. But third and most significantly, we should resist it because it inhibits what is most important about law, that it could serve as the instrument by which we can reimagine and reconstruct the established institutional structure. In law, the institutional life of a people is presented at the level of detail, at which its contradictions become manifest, rather than in the form of abstractions like capitalism or like the market economy. Now, my second proposition is that what stands behind this supposed wave of the future in legal thought is the last great institutional and ideological settlement in the advanced societies, the social liberal or social democratic settlement that was organized especially in the aftermath of the Second World War and presaged already before that war. A settlement under the terms of which there was a renunciation of any attempt radically to revise the systems of power and production, and in exchange, an opportunity to humanize the market order, especially through compensatory redistribution by tax and transfer. And the connection between that practice of legal doctrine and this settlement was that the forms of individual and collective self-determination shaped by the existing institutions was accepted, and all law was then reorganized dialectically as a combination of rules and rights defining popular self-government and individual self-determination on the one hand, and other rules and rights designed to ensure the practical conditions for the effective enjoyment of those same rights, but all on the basis of the acceptance of the general order. Now, this social liberal and social democratic settlement, which has been progressively liberalized or hollowed out in the last decades, is incapable of serving as a basis for solving or even addressing any of the fundamental structural problems of these advanced societies. And in particular, three great problems. The first is the problem of the hierarchical segmentation of the production system, now divided between vanguards and rearguards, between advanced and backward sectors. And we have a new productive vanguard in the world. We call it the knowledge economy. It exists in every sector of the major economies of the world, but in each sector, it exists only as a fringe that excludes the vast majority of workers and of businesses. And this insular character of the new productive vanguardism then becomes a motor of economic stagnation on the one hand, because it denies the most advanced practice to the majority and condemns most of the population to some kind of make work. And on the other hand, to an aggravation of inequality. The economic inequality is rooted in this chasm, in this growing chasm that separates the advanced sector from the rest. Second, it is incapable of assuring a basis of social cohesion. The only form of social cohesion in this state is money transfers organized by the state against the background of a high level of ethnic and cultural homogeneity. When migratory flows, for example, erode the basis of ethnic and cultural homogeneity, the result is to expose the inadequacy of money as a social cement. The only possible basis of social solidarity is the multiplication of forms of action, of collective action, people doing many things together. The third reason why this settlement is inadequate is that it provides no basis for transformation except in the presence of crisis, in the way in which it organizes politics. It creates low energy democracies that depend on trauma in the form of economic ruin or of military conflict as the enabling condition of transformation. To my mind, the two most important projects that one could have in this situation are, first, the creation of a knowledge economy for the many, a socially inclusive, productive vanguardism, a productivism that embraces the majority of the population rather than being confined to a small elite. And the second project is the creation of a high energy democracy that no longer depends on crisis to make change possible. The relation between the inclusive productivism and the high energy democracy is the single most important programmatic advance that we could have. That dominant form of legal thought should be resisted and condemned because it stands opposed to any such transformation. It's not an adequate instrument for imagining such an alternative. Now I come to my third proposition. And my third proposition is that in the attempt to reimagine and redesign this inherited institutional settlement, there is a particular toolbox of legal categories that we would have to develop. These legal categories are not the instrument of any particular program, of any one program of transformation, but rather they describe an intellectual and political space of a family of programs that all could serve this purpose of generating an alternative to the social liberal or social democratic settlement, and in particular, establishing a basis on which we could hope to achieve the combination of a high energy democracy with an inclusive, productive vanguardism. So first, there are the categories of private law. And there are two legal concepts that are crucial there. The first regards property. The substitution of the unified property right by a conception of property as being consisting of a disassembled bunch of powers vested in different tiers of right holders. So in other words, we can imagine that a market order, rather than being fastened to a single version of itself, and in particular, a single property regime, contains within itself a whole range of property regimes of different forms, a unified property right, joining together all of the component powers of property and vesting them in a single right holder, the owner, would be only one of these regimes. And the importance of that is to make it possible to combine a great democratization of access to the means of production with the possibility of the aggregation of resources at scale. And the second great category in private law has to do with contract. The bilateral executory promise an arm's length bargain for an exchange of performances at some instantaneous moment in the future should be dethroned, should be denied its central position. And we should imagine a whole range of contractual forms emphasizing the ongoing incomplete agreements, the relational contracts that are in fact the heart of much of social and economic life. They are necessary to the cooperative competition on which an inclusive knowledge economy depends, but they're also necessary to a broad form of associations. A characteristic of a legal characteristic of the social democratic or social liberal settlement is that it superimposed a new body of public law on a largely untransformed body of private law. And now we would have to change this. A fundamental distinction between what we would do now and what we did then is that private law would itself be reimagined. Now, the second category in this toolbox has to do with the relation between the state and independent civil society inside and outside the market. The state has to be able to act experimentally. By that, I mean that our idea of the rule of law has to change so that we don't imagine that the state acts in law only all at once by either by rules that apply to the whole of society or not at all. We imagine that the state can try things out. And this experimental character of administrative action then has to be combined with two sets of innovations. One of them is vital to the market, to the economy. The state should be able to partner with small and medium-sized firms and with groups of workers and technicians to bring them up to the level of the vanguard. And the other has to do with the provision of public services. The state should provide a universal minimum, and it should also operate at the ceiling in the development of the costliest and most complicated public services. But in the broad middle zone between the floor and the ceiling, the state should be able to partner with independent civil society, acting not for profit, through the form of cooperatives, for example, of educators or health providers, to develop alternative forms for the provision of public services. The best way to enhance the quality of public services, which make people, which define the future of society, is to diversify the forms of provision. The third chapter in the toolbox has to do with the relation between labor and capital. The immediate problem that we have is the consignment of larger and larger part of the labor force in these societies to conditions of precarious, unstable employment. So they need to be organized and represented. And to the extent that they are not organized and represented, direct legal intervention in the employment relation. For example, to establish a principle of price neutrality so that work performed under conditions of unstable employment is remunerated at a level comparable to the similar labor undertaken under conditions of stable employment. But this emergency response to the problem of the precariousness of labor is simply the front line in a more fundamental project. The more fundamental project is to create the conditions in the future for the gradual supersession of economically dependent wage labor as the primary form of free work. The liberals and the socialists of the 19th century almost invariably believed that this form of work, wage labor, should give way to the higher forms of free work, cooperation and self-employment. because wage labor retained characteristics of serfdom and slavery. But they were never able to show how the predominance of self-employment and cooperation could be reconciled with the imperative of economies of scale. That's why this transformation in the relation of labor to capital would have to have as its basis an experimental diversification of the property regime, the transformation of private law to which I referred at the outset. The fourth element of this toolbox has to do with the organization of democratic politics. All of the democracies in the world are weak democracies that perpetuate the rule of the living by the dead and make change depend on crisis. So then there's a contradiction between this democratic politics and the realities of class society, and the characteristic way in which the constitutionalism of the 20th century has resolved this contradiction is by multiplying empty, unkept promises of social and economic rights. This is what I call Weimarism. So the constitutions have been filled up with all of these promises, not backed up by any institutional machinery that would be capable of fulfilling them. Now, what is the alternative? The alternative is to organize the institutional arrangements of a high energy democracy that elevates the level of organized popular engagement in political life, resolves impasse quickly through comprehensive programmatic plebiscites or early elections, and treats strong initiative by the central government and radical devolution as complementary rather than as opposites, and enhances the institutions of representative democracy with some of the features of direct or participatory democracy. In this way, we create a form of political life that renders the impulse to structural transformation endogenous, internal to politics, and diminishes the dependence of change on crisis. My fourth proposition is that we have a problem, an intellectual problem in the prosecution of this project. The intellectual problem is that we have now in the world no usable way of thinking and talking about structural change, structural discontinuity, and structural alternatives. We had a way in Marxism that in which the recognition of the possibility of changing the structure was compromised by a series of deterministic illusions, that there's a closed list of regimes, that each of these regimes is an indivisible system, and that there are laws governing the foreordained succession of these regimes in history. All of that is false and has become literally unbelievable. The contemporary social sciences, on the other hand, provide no way of thinking about structure whatsoever. Each of them, in its own way, suppresses the imperative of structural vision and severs the vital link between insight into the actual and imagination of the adjacent possible. Now, legal law has a comparative advantage in this. So it's not simply a victim of our lack of ways of thinking and talking about structural change. It can contribute to the solution. It has two comparative advantages. The first advantage is that it represents the institutions at the level of detail at which the possibility of dividing them up, of treating the structure as a divisible one, rather than as an indivisible system, becomes manifest. Real structural change is almost always fragmentary. The idea of total change is an illusion. And this is one of the illusions that results from the Marxist idea of the indivisibility of the system. And the second comparative advantage is that law represents the institutional details always in relation to the received understandings of the interests and of the ideals that make sense of them. It is the institutional form of the life of a people represented in relation to the established understanding of interests and ideals. Now comes my fifth proposition. So my fifth proposition is about the problem of agency. What should we expect the legal theorists and the legal academics to do? I don't think it's realistic to suppose that they would be the agents of any particular alternative. They're too diverse, they're too disorganized, and they're too marginal in their respective societies. So what is a more realistic objective? The more realistic objective is that they could begin to create a space for a different kind of conversation, a space for a family of institutional projects that all began to revise the terms of the social democratic or social liberal compromise. And in their individual capacities, as affiliated or not to particular parties and movements, they could be the authors of particular programs. But in their collective capacity, their role would be to be the designers of this larger space. The world, the social world, is always organized to reproduce itself. And therefore, when there is a transformative task in the world, the agent capable of enacting it never exists. And the situation that I'm describing is no exception to that. So what do? We take an existing agent and we make that existing agent do something incongruous, something that has no intrinsic relation to what we're expecting it to do. And then later on, we create the appropriate agent. And that's then the significance of this fifth proposition, that I'm proposing something incongruous for us to do. That is, the legal thinkers, the legal notables, which is to create in our societies a different kind of conversation about the future possibilities of society. I give it back to you, Klaas, and I hope that then we can have a discussion.